You're good. Court does call the case of the people of the state of Michigan versus Raymond Smith. Counsel, state your appearances, please.
Good afternoon, Your Honor. Attorney John Freeman on behalf of Mr. Smith, who is seated at the table.
All right, very good. And I believe this is your motion.
Yes, Your Honor. There are two issues before the court today.
All right.
The first has to do with prior acts, and the second has to do with a prior allegation by the complaining witness, that being a false allegation of a sexual assault on a different occasion involving a different individual. I'm not sure which one the court would like to take up first.
Well, either. Let's deal with what I think, quite frankly, from my standpoint, maybe the easiest one, which was a prior act regarding a prior individual.
Okay.
So go ahead.
Your Honor, I think that the law is very, very clear there. I trust that the court has had an opportunity to read the written filings.
Absolutely.
So I'm not a big believer in wasting the court's time. If you tell me you've read it, and I assume that that's in.
I've read it, but this is the one with the Ipsy Police Department report.
Yes.
And I guess the question I have, is that really a prior act as we're looking at it, or prior false claim?
Your Honor, in my estimation, it is. If you look at the police report itself, it clearly lays out that the complainant in this particular case made an allegation. It was a very specific allegation. There were very detailed steps that were taken by law enforcement to investigate that allegation. It ultimately came down to that allegation not being pursued by the prosecutor's office. The alleged perpetrator in that instance was prepared to take a polygraph examination. That much we know from the police report, and the case ultimately was not prosecuted. Now, I thought it was fairly curious in the people's response that they indicated that the reason that case was never prosecuted had nothing to do with credibility. However, they offered no explanation for why that case wasn't prosecuted. We've all been around long enough to know that if there's any credence given to an allegation of that nature, it's going to wind up in a prosecution.
Well, maybe not.
I think it would be incumbent upon the people then to establish for what the reason was that there was no prosecution. And if they want to put some sort of evidence forward that could be subject to.
Well, the case didn't close, though, right? I mean, it didn't close because he was supposed to come in and take a polygraph, did not.
I'm sorry, Your Honor.
He didn't come in and take a polygraph.
Your Honor, I think that that's unclear from the report that I was able to obtain via FOIA. But I think the ultimate issue is whether it is fair game for purposes of cross-examination of the complainant during the testimony in this particular case of the preliminary exam. Is it fair game for me to be able to ask her questions about that? The case law is crystal clear, which I cite in the written motion, that a prior allegation of sexual assault that turns out to be unfounded is more than fair game. It cuts to the very core of the.
But, and I guess I'm not disputing your reading of the law, but was this unfounded?
Your Honor, from my estimation of my assessment of the police report is yes, it was. If it was founded, there would have been a prosecution.
Well,
and I certainly have a good faith basis to be able to ask questions about that.
Okay, but some of that, maybe it's something you know or don't know, might also have to do with the department I'm dealing with. in terms of the Ipswich Police Department. I mean, I'm not going to sit up here and disparage them, but there were, shall we say, points in time where certain cases, there really wasn't a determination as to whether or not they were true or not, as opposed to how they were investigated, which caused some problems. I don't know if that fits into this category, quite frankly, but that's why I'm saying there can be a number of different reasons as to why this did not go forward, but I don't know that.
Well, Your Honor, I can only go by what the people have said in response. And on page 9 of their response, paragraph 19, it says the prosecutor's office did not, in bold letters, deny charges because of any credibility concerns. That's all they say.
Right.
There's no,
which
there's nothing offered by way of explanation. So I think there's a factual issue here that needs to be resolved, perhaps. Because certainly their records would show why it was denied. They're not saying we never evaluated it. They're not saying we were never asked to issue a warrant. They're not saying that at all. They're just saying we didn't prosecute. Our decision not to prosecute had nothing to do with credibility. And that's where they leave it. They offer nothing additional. And Your Honor, it's quite possible, that individual that was falsely accused in that case is a known person. So you always have the possibility that the defense could put a case on at the exam.
Any response to that portion of the
Yes, Your Honor. I will say that the defense continually uses the word false, I think, without really substantiating that. According to People v. Butler, which was just decided March 25th of this year, there must be a showing of at least some credible and potentially admissible evidence that the prior allegation was false. And I don't think that defense counsel's own feelings about how the police report reads is a determination that this report was false. The people do, of course, deny things for any number of reasons, victim credibility being one of them, suspect not coming in for a polygraph being one of them. I will say that I don't think this was put in the response, but the reason stated on the denial was administratively denied as no supplement report has been submitted after two furthers. Unknown results of polygraph follow-up with victim.
And see, I did not know that, but I will just say, and again, it's something I don't know that counsel would necessarily know.
Yes.
But those issues with YPD, that's almost what it sounds like to me. If I were to read it, if I hear that, it sort of goes into that area. And I'm not, prosecutor sends out, as I'm to understand the reason for the part of the denial is, we need something else, basically, to the police department. There is no response. And it sounds to me like they did that twice.
Yes, that's correct, Your Honor. So the people followed up, furthered the case twice for whatever reason, following up on the polygraph, and per the report as well, the suspect scheduled a polygraph or tried to, but then changed his phone number and never showed up for a polygraph. So that's failing to take a polygraph, and a reason among other things that we might deny a case. I obviously wasn't in the head of the APA that did deny this case, but those were the reasons stated. I will say that also the people attached the case to their filing. It is unpublished, but I do think it brings up some relevant points. In this case, the defense had presented the police report, which the court said was essentially a he said, she said situation, and no proof was submitted demonstrating the victim actually made a false allegation of sexual assault. And in that case, the Calhoun County prosecutor's decision to dismiss the charges certainly didn't equate to concrete evidence that the victim made false allegations of sexual assault. I think defense is focused on that charges weren't pursued, and that equates with false allegations. That is not the case. The people do not charge every criminal sexual conduct case that gets submitted to us. We evaluate those cases based on the strength of the fact, victim credibility certainly being part of that equation, but we wouldn't charge every case in which there are allegations made. So I would ask that, or would say that I don't think that defense has made a showing that there is credible and admissible evidence that these allegations were false. I don't think he's overcome that required hurdle in order to question the victim about this.
Go ahead.
I find it understandable, but curious that now here we are at the hearing, and this has been pending for a significant amount of time, and now, only now, are we hearing what the explanation is supposedly for why that case was never prosecuted. I think that I'm entitled, as a matter of discovery, to the firsthand information from within the prosecutor's file on that case. It sounded as if the assistant prosecutor was actually reading from something. There has been no factual representation made prior to the statement of the APA here today. I certainly don't question that she's stating what her understanding is, but at this point in time.
Well, as I understand there should have been a form. You FOIA'd this from YPD.
Yes,
right?
We never FOIA'd anything from the prosecutor's office itself.
No, I got you. But the referral form, and I can't remember what the form is called. It was blue. That's what, in my day, it was blue. That's what I remember. That should have been or could be, I guess, attached to the YPD report, but I don't know.
You're talking about the denial reason, Your Honor?
Yes.
Yeah, I'm not sure if that would be attached to YPD or not.
I know they get a copy, but I don't know on a FOIA request what they would give.
And Your Honor, I spent 14 years on the other side of the courtroom, so I could see an argument being made without a court order that, hey, the communications between the police department, the prosecutor's office,
right,
not subject to FOIA. That's why at this point, and I can certainly prepare something in writing, but before the court makes a decision on this, I'm going to ask for the actual file.
We have that denial form.
I have the denial. I don't think that defense has any right to the discovery of the entire file of that case that, again, is a case that was denied, that he is now stating that he thinks it's false. He doesn't have the right to that whole file under any discovery rules.
Well, which file are you talking about? Because I'm going to have a police file. I'm going to have a prosecutor's file.
I want both.
Well,
I want both because I think both.
Where is your entitlement to the prosecutor's file?
Your Honor, this now has squarely become an issue that I think from a factual standpoint needs to be resolved. The people have acknowledged, and it's common knowledge, that sometimes cases are denied because of a credibility determination that is made by the complainant. If that's and the prosecutor saying that's not why it was denied. So I think that out of just due process and fundamental fairness, when this has become an issue, a factual issue, I've had a good faith basis to move as far forward as I have moved when I see that there was an offer made in a police report for a polygraph and the case was denied. I think I certainly have enough to reach a common sense conclusion that at least part of the reason, or maybe the sole reason for the denial, was based on the conclusion of credibility by the prosecutor's office. If they're saying, no, we have information that refutes that claim, then I think I'm entitled to see it.
I just stated that the direct quote of the denial on the record. I can certainly see if I can send him that. I would need to confirm that, but I do not think it would be appropriate for us to send him the whole file. Some of that would be work product. I can send the reason for the denial, but I think that would be the only appropriate remedy for what he's asking.
And Your Honor, they certainly could make a request to submit it in camera and let the court review it all. I want someone other than the prosecutor to review the entirety of the prosecutor's file and the entirety of the police file.
Okay, I don't even have a problem doing that, but what tells me, even on a just any basis, that this is a false claim?
Your Honor, there are two diametrically opposed versions in the police report of what supposedly happened.
But that doesn't mean that it's false,
But
is it?
But you have the alleged perpetrator saying that's not what happened. We never had sex. We never entered the house. I'm willing to take a polygraph to that effect.
And doesn't.
We don't know.
Well, no, he says he doesn't. That's what I have from the police report, that he doesn't take the polygraph.
Your Honor, there could very well have been a determination made that she wasn't credible, aside from the failure to take a polygraph, if that's in fact what happened. When I prosecuted...
So, but hold on. If, let's say the prosecutor comes to the conclusion, we're not sure what happened. We have these two stories. We're not sure what happened. The alleged perpetrator is going to take a polygraph. That may solidify it for us, but we just don't know. That person doesn't take the polygraph. The prosecutor makes the decision to not go forth. What makes that then false?
That at least calls into question the credibility of the complainant. And the issue is, can I ask questions about that during cross-examination?
No,
Can I
it doesn't call into... How do you get there? Because all it does...
Because if they believe her, they prosecute. They don't make a determination.
Or we don't know. We don't know. And then I don't have the one piece that may help us make our decision. If that's the case, that doesn't mean that what she has said is false. So does it?
Your Honor, it calls it into question. And then as part of my client's right front as accuser, my client's right to a full and effective cross-examination, I think it's fair game. And if we track down that particular individual that was the perpetrator and subpoena that person to testify, there might be contrary evidence.
Yes. But if you do that, don't I have a different ballgame here?
The threshold inquiry is whether that it would be admissible in a defense case in chief at the exam, and before we even get there, whether I can even ask questions.
But counsel, if you had this other person that said what she relayed was absolutely false, and that it is a false allegation, I'm in a whole different posture here, aren't I?
But I think we're in that posture already based on the police report, Your Honor, because the alleged perpetrator's statement is in that police report. And he says it never happened.
Right. She says it did. He doesn't take a poly.
So what? Let's suppose, when I was a prosecutor, we never had polygraphs.
Okay,
This was in New York City in the 90s. We never made a decision based on a polygraph because subjects were never asked to do a polygraph.
Okay, but I'm not going based upon your history.
Well, I'm just...
I'm just not.
There's
That's
two
not
ways
how
to
I'm
look
ruling.
at this, though.
What I'm looking at is what tells me this story is false. I spend my life with two versions of something that has happened, at least two. But that doesn't mean always that one is false.
The relevant question is whether there's enough there to call into question her credibility to make it relevant pursuant to the case law that allows...
And I don't think there is. That's what my point is. If this other person was here and said, oh, everything she said was just absolutely untrue. Blah, 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 blah. I didn't take the poly because, I changed my phone number, but was here and said, untrue. I think I'm in a different spot. But that's not where I am right now.
Well, Your Honor, I agree with that. I think, however, getting back to my request for the court at least to do an in-camera inspection of the police file and the prosecutor's file, because maybe there's something in there that suggests that an assessment was made, that the complainant was untruthful. I don't know. I'm speculating at that point just as much as anybody else is that's not an employee of the prosecutor's office. And what I'm asking for is the court to exercise its gatekeeping function and ensure that my client is afforded due process, and for the court to order that material to be produced so that you can review it.
Ms. Willingberg, what do you say to that?
I think that we have not passed that initial hurdle. So in order for honor to have an in-camera evidentiary hearing, the defense has to provide that initial showing that these allegations are false. And from defense's statement, my understanding is he believes they're false because there are two different versions of events outlined in the police report. That is probably 98% of police reports. And significantly, the same in the instant case that we have the victim statements about what happened, and then we have defendant statements about what happened, and defendant statements in the motion, his rape shield motion. So I don't see how those two things are any different. Like, he hasn't made any showing that these allegations are false. I would be happy to provide that denial. I'm going to redact the suspect's name as it was rejected with information you received from YPD. I will turn it over to defense, but I don't think that he has made that initial showing that would warrant it.
Okay, let me ask this then. Outside of the one form,
Yes.
right? What about the court getting the entirety of the YPD file? I have some concerns about saying I want the prosecutor's file. I just do, as if also I were going to look at defense. I don't think that that's the court's role. The police file can certainly, I think, be something different. So what's the people's position on the court ordering YPD to turn over the police file?
I think my argument would be the same, that I don't think he has made that initial showing to that point, because that would be an in-camera, essentially an in-camera evidentiary hearing, as in your honor is reviewing information.
Well, but I think I'm in it right, but potentially there could be, and I guess this is the way I kind of look at it. I've got 2 requests to further without response.
Yes.
I might come to a different conclusion if I didn't have that about the YPD file. Because, I mean, I don't know what Mr. Friedman expects to see or anybody else expects to see, but maybe there is some merit in the prosecutor sends it back, says, you need to do something else, police agents. Prosecutor doesn't get a response, right? At least as I'm to understand what you're saying. You do it again, they're not getting a response. Defendant doesn't then, at least if that's the chronological order, doesn't take the poly. Okay. I don't know that that means what she says is false at all.
Right.
But it at least seems to me that it's can be slightly different than what I would see in some cases where my curiosity comes in that there's not a response to the request to further. That is what it is. And one thing that I brought up to Mr. Freeman, that those of us here know, and I don't know the time frame, that there are certain, trying not to be too pejorative,
This was 2017.
Pardon?
The time frame of the other matter, 2017.
Yeah. And I'm not sure when the issues started beginning to happen. And I've had to deal with those issues. Mr. Freeman would not be, certainly I don't think, privy to that as what I was saying. I think given at least what the court knows may be an issue. Seeing certain things that may, to a certain extent, raise a red flag, but may not. It may be nothing.
Okay.
But the failure to respond to the request further may be something that the court needs to look at. I realize this might be a bit unorthodox, but I'm also thinking I'm dealing with a department that was in a circumstance that may have been in an unorthodox place at that time.
Sure.
So, in fairness, what I will do then is I will order that the Ypsilanti Police Department turn over their entire file regarding this case directly to the court.
For in-camera review.
Only for an in-camera review. They are to turn it over directly. The procedure that I set up, that they are to deliver a copy of that entire file sealed to this court, to my attention. They should also indicate in there to mark it confidential so that it's not opened up front. And then they will get that to me and I will review it.
And Your Honor, I think that I just want to clarify for the record. I think the court was probably pretty deliberate in the terminology that you used. It wasn't just the report, it was the entire file. For the Ypsilanti Police Department, I want their entire file. Correct.
And just clarify.
Which in and of itself be an issue. Go ahead.
Yes. Does Your Honor need an order for that, or?
Yes, there's going to need to be an order for my signature that then needs to be turned over to the Ypsilanti Police Department. Okay. So counsel for the defense will prepare the order. You kind of won.
Check.
All right. So yeah.
I will do that. And I'll check with them on the prosecution on the language. Hopefully we come to a meeting of the minds.
That's fine. And if you need to make a call to the office so we can clarify the language, I don't have a problem. So we don't have to come back for a full hearing on that language. I'll participate in that. Okay.
Okay.
All right. Your next issue.
Your Honor, the second issue has to do with my intention to introduce evidence during the preliminary examination, potentially in a case in chief during the preliminary examination, but certainly on cross-examination of the witness regarding prior consensual intimate acts between the complainant and my client. Those intimate acts include touching of body parts over and under clothing, cuddling and groping, as well as digital penetration. My notice also expresses an intent to get into prior drug use by the complainant. I don't think that that's technically covered under the Rape Shield Act, but I threw that in there as just something that, in the interest of full disclosure, that I intend to get into, although it may not be technically the subject matter of today's hearing. Your Honor, there were also text messages between the complainant and my client regarding prior consensual intimate touching and sex acts, as well as text messages regarding exchanging sex for money. I should note for the record that I have provided to the people And this was done after they requested discovery from the defense. On January 29th of this year, I provided 80 pages of documentation containing text messages between the complainant and my client. In addition, I also attached 2 recorded conversations between the complainant and my client from the evening in question. So I just wanted the record to reflect that I did disclose that material, and the people have acknowledged receipt of it. And Ms. Reiser, who I believe is the assigned prosecutor, indicated that she was going to review those text messages. The reason I highlight that is because in their response to my notice, they indicated that they were unaware of or had not received any of those text messages. So I've turned all of that over. Your Honor, I trust that the court has had an opportunity to review the written filing. I'm not going to belabor all of that. I think the law is clear. It's directly material to the defense in the case relating to the issue of consent. It's also a matter of my client's right to present a defense, his right to confront his accusers. I think this squarely falls in the realm of the type of evidence that is permitted pursuant to the statute, being that it is prior conduct between my client and the complainant, and that it is not unduly prejudicial. The purpose is not to harass, embarrass, or otherwise go after the complainant. It is merely to establish facts from which the defense theory flows.
Is the period in time from of these alleged other acts, what period in time are we looking at?
We're talking about within days, weeks, and months of the alleged act.
Of this alleged fact?
Yes, the alleged offense, I believe, the offense is alleged to have occurred, I believe, in August. Some of these text messages are just days prior. Some of
But I guess my point, maybe I'll put it this way. As I understood the motion, we're not looking years.
No,
or
absolutely
even a year.
Correct.
Okay. Twilling.
Thank you. I am going to address the mind-altering substance part first. I don't think that this is an appropriate place for this request in a rape shield motion. I mean, defense can certainly try to wade into that at the preliminary exam. People can make the appropriate objections at that time, but I don't doesn't rule out whether that an acceptable line of questioning or not at this point.
Well, in substance, I would agree, and I think Mr. Freeman was even conceding that point, but I don't want to get into the circumstance where I say, well, I'm not ruling on that, but then we get to this questioning, and are these mind-altering substances or whatever, are we going to have a circumstance where those relate specifically to these prior acts or not? I mean, I don't.
Your Honor, I think it's arguable that they do, because there were certainly times where the prior acts that we're talking about were commingled with the use of other substances.
What substances are we talking about?
Yeah.
We're talking about, marijuana, which is part of the instant case, but we're also talking about mushrooms, and there's also some communication relating to other narcotics.
Between the two of them?
Yes.
And that's contained in the text messages and recordings that have been provided?
More the text messages than the recordings.
Okay. Just so that we're all clear, I realize you turned them over about 2 months ago, right?
Month and a half.
Month and a half ago.
And specifically the ones that come to mind right off the top of my head are mushrooms, psychedelic mushrooms, as well as cocaine.
Okay, let me just make sure, much like, had the people had an opportunity to go through those text messages as well as the recordings that have been turned over?
My understanding is yes. First
Okay.
supervisor has those details.
Okay,
Yes.
Go ahead. Well, I'm going to decline to rule because I don't think it's part of I really don't think technically it would be part of this. Although I realize I may be creating something that may cause problems further at preliminary examination where these substances may relate to acts. I'll kick that can down the road. I'll deal with it when it comes up. I guess that's probably the best way to do it.
As to my further response as to the Rayfield notice filed by the defense, I would say he probably has a right to ask about prior consensual acts, but that upon information belief, our knowledge of the victim is that he denies any prior consensual acts. So if defense asks about them and then she says no, that would seemingly be the end of the line of questioning unless defense has, and to my knowledge, I have not reviewed all the text messages, but I don't believe there are explicit text messages that describe any prior acts. So I am just questioning what would be the allowed line of questioning from the defense. And if the victim testifies that this was it, we've never had a consensual sexual relationship before, does that line of questioning then end?
Well, I hate answering things in the hypothetical without
Sorry.
seeing everything. No, it's okay. I mean, it's a fair question, but it's a difficult question for me to answer because I haven't seen the text messages. So I don't know what they say, number one. And God help me, I always hate reading text messages because we can see a certain response or a certain statement. Mr. Freeman's going to have, and his client are going to have an interpretation of what that means. And then I'm going to have this meaning. And then I've got to figure out what it means. And so, while it's a good question, Ms. Willenbring, I don't know that I can give a definitive answer because I don't know what they say. And if the complainant says, okay, let's say, I'll just try to do it. There's a text message that says, I really enjoyed last night. Okay. I'm going to have your interpretation of what that means. You're going to have she's going to have her interpretation of what that means.
I do think in that circumstance, sorry.
Pardon? Go ahead.
I think in that circumstance, the defense could ask, what did you mean by that? And then if the victim says, we hung out or whatever, I don't think, if she's already testified, and this is all hypothetical, so I
know.
Wading in is maybe fruitless, but if she's already testified they've never had an intimate relationship before, then to me that line of questioning is foreclosed because you can't continue to badger a witness about something that she has already said has never happened before.
Okay. So I think then I'm absolutely left at a point that I don't know that I can even rule on this. I would say that he can ask the question, and it's going to be, at least as I'm looking at it now, it's going to be a call that I'm going to have to make on the spot because I mean, it may be that Mr. Freeman asks a question, then she gives a certain response. I can't say he then has to stop because there may be something else that he's going to at least submit relates to that question, which gives some clarification, which may indeed show, I'm not saying that it's going to show this, but it may indeed show that she's not telling the truth. And so he ought to be able to explore that, certainly. So I can't say it's going to be cut off much like what you said, but I would hold the defense to the task of showing something as to why the question would continue. Does that make any sense to anybody? It made sense to me, but that's in my head.
It does make sense.
Okay.
I think it makes sense.
All right. So I think that's where I will leave it with that you can ask the questions, certainly, of their relationship. All right. And you have the documents that defendant submitted. So you have that. And there's nothing else regarding communications regarding their relationship that may come in that you're aware of, at least.
Not that I'm aware of.
Okay, anything else real hard that you guys want to give me at the end of the day?
I'm
No.
happy to make up several hypotheticals for you, Your Honor. Nothing.
I would know of hypotheticals since law school, so I just soon not go back there.
Yeah, I hear
I
you.
have a law student.
Your Honor, I do have a housekeeping question.
Yes, sir.
I know where we've gotten to so far today. This exam is set for 3 weeks from today. So I just don't know what the court's on the timing.
Okay, so some of that's going to depend on how fast YPD can get those documents. We're set for the 23rd, right?
Yes.
Okay. So 2 things regarding what's the 23rd? Oh, and?
Yes, sir.
So,
Yes. Yes, in the morning. Let me check on that, but yeah, we can do it.
okay. Okay. That's why it was ringing a bell.
Yeah.
Will work. Okay.
Off the top of my head, we at least had 4, but
But I haven't gotten near there yet.
correct, and they may not all be updated.
Okay. All right.
Your Honor, for scheduling purposes, I just wanted to know, you may recall that there was a motion the last time to compel for discovery, and I was working with the prosecutor. We got some of that. I don't think we've gotten a full response to all of it yet. I recognize that the assistant prosecutor here today is not the person that's maybe is case as the assigned prosecutor, Ms. Reiser. But I've had some communications with her as early as this morning about that additional discovery. So I don't know. I just want to telegraph.
Okay.
Could be this outstanding issue that we might be waiting for more from them, from the prosecutor.
And Ms. Willenberg, you don't know. Ms. Reiser was dealing with that. Is that?
That's correct, Your Honor. I do know she turned over some additional information today, but I don't know certainly, like, specifically what else she might be waiting on.
Okay.
But I would suggest we leave it on the 23rd just for scheduling purposes, and then if Your Honor does not have that final say in 2 weeks.
That's funny. Go ahead.
And the people can certainly make an effort to follow up with YPD and see if we can help facilitate that, but.
Okay, because and that sounds maybe what I should do is leave the 23rd. That way, if there are still discovery issues, we can try to deal with that on that day. We can then deal with the file and whatever. Okay. Now, I can then, let me just say this. I can do one of 2 things. I will leave the 23rd. I can give you, because we set the homicide on the 7th, right? I can give you a date so that at least you would have that morning out, and then I'll know on the 23rd, I can then cancel it on my doc. Everybody can cancel the date out, but it sounds to me like I'm leaving it on the 23rd, but we're not looking to go on the 23rd. It's going to be a check-in kind of point. And then I could give you the morning of May 6th, that Monday, as a special time to go.
Federal matter.
They'll wait. No.
That's right.
Um,
jury trials.
Okay, all right, then I'll quit trying to be proactive. What we'll do is I'll look at it come the 23rd, see what I have, and then we'll try to work out calendars then. All right, sound good, folks? All right.
So, Your Honor, just to clarify, I've written down April 23rd. That's really a check-in date.
Yes, I'm not going to expect the people, so the witnesses for the people don't have to be here on that day.
Okay.
Okay, we won't look to go on that day. All right, I think we need to make sure everything is taken care of. You guys are gonna work on that order and then get a copy to me so that we can send it out, or it can be sent out to the YPD and see what we get. Okay. Anything else?
Not from the defense.
Nothing.
All right, great, thank you.
Thank you.